Thank you, Mr. Chairman and members of the committee. I promise to be brief.
That's okay.
And I'm happy to answer any questions. My law firm has represented the Board of Psychology for 35 years. Amy Groves Lowe. I'm with Taylor Porter, and we've represented the Board of Psychology for 35 years. In that time period, we have never had an appellate court reverse a decision of the board based on due process or any other grounds. And that is because this board has followed the law set forth in the Administrative Procedure Act and the case law that defines it, which is a well-worn path that provides all the due process at every stage to a licensee. We have clear law, we have black and white law, we have fair law, and we have judicial oversight and review that is included in the Administrative Procedure Act that ensures that licensees who have had their rights violated are able to come before a separate, neutral, impartial body and state their case and have the due process or any other issues reviewed. That process is taking place. Our board is doing that well. Checks and balances already exist within the Act. This bill, as amended, would eliminate the basic elements of the Administrative Procedure Act that are working effectively. First of all, the amendment to have the right to have an ALJ to hear the case, this would eliminate the whole purpose of having a professional board. The courts have said that it is important that state agencies and licensing boards have members of their own profession rule on issues of licensing and rule on issues of discipline because they are in the best position to understand their own profession. If we then have members of the ALJ doing these roles, they don't have that expertise. So cost, one of the issues that you mentioned, is going to be greatly affected because both sides, both the licensee and the boards, will have to hire additional experts to testify about what the standards are in their field, in their profession, so that the ALJ can fully understand before they rule on any issue. In addition to that, right now, our courts give deference to boards based on their professional opinion, based on their professional background and the information that they have. All of that case law would be gone with this bill. All of that would be eliminated. Secondly, the amendment to raise the standard of review to clear and convincing evidence. This is a standard we use in criminal proceedings, not in civil proceedings. This is a civil proceeding related to licensing, and it's too far. Third, the removal that there's been a lot of discussion about producing the entire file to the licensee. And Senator Peacock, you mentioned about the whistleblower concerns that you have. In addition to that, this would throw out any attorney-client privilege that the board has with their attorney because they would have to produce everything, every work product, every attorney-client privileged conversation, all of that would have to be produced. And this is in violation of existing law and privilege. The item in the amendment about having a counsel at all stages in the proceedings, does that include, as it did in the original bill, in every conversation that the executive director has with the investigator? Again, that involves privileged conversations with the board attorney. These are all issues that would completely eliminate existing law related to administrative proceedings. The right to discovery is already in Title 49 under 956. And I understand that this body wants to prevent a state agency from keeping individuals from working. I understand that. We don't want to have any state action that takes away an individual's right to work. But what the Administrative Procedure Act does is it balances the right of the individual to work with the important state duty and obligation to protect the health and welfare of all of its citizens, not just the licensees, all of its citizens, everyone who is going to a professional for help. And if we take away these essential elements of the Act, we will destroy that balance. We will have it totally tilted in one direction and not balanced, which is the purpose of checks and balances and the purpose of having oversight that is already provided for. I understand there may be some boards that have specific issues, but this Act, as amended, would affect all boards, including those who the courts have affirmed are operating with due process and applying the law as it's written. Our board has the same purpose your legislative body does, which is to protect all citizens, all of us. And we need to do that in a way that upholds existing law and doesn't degenerate it. I will state lastly that there was a complainant earlier who talked a lot about specifics about my board, about the psychology board today and last week. And I will remind this committee that the witnesses were ordered to tell the truth and tell the whole truth. And there were a lot of things that were left out, and I'll be really brief in addressing just a few. First of all, the complainant did not mention that there were numerous charges filed against him that, without getting into detail, pose significant harm to the public. It's all a matter of public record because a lawsuit has been filed in this case. It also was not accurately explained to this committee that at the administrative proceeding, that complainant was allowed to present witnesses. He had an attorney. He presented evidence. He presented all of his own witnesses. It was a full hearing. There was no due process violation through that hearing. And that complainant did file an appeal with the district court and with the First Circuit, both of whom said that the board did not violate any due process rights of that complainant. So just to be clear to this board, that is not an example of a board misapplying due process. This board has done them.
We're not here to make that decision. We're here to make the decision on whether or not we're going to apply the standard that he wants to those courts.
Absolutely,
okay,
but this body should not be put in a position of trying to circumvent pending litigation. That's not the purpose. The purpose is to look at whether or not the Administrative Procedure Act already fairly balances the rights of the individual to employment and the state obligation through its boards to make sure that the health and welfare of its citizens is being protected.
Thank you.
Thank you.
Wait, hold on. Senator Alon.
Yes.
Could you speak to just a minute the cost and who would bear
Yes.
it if this was enacted?
Absolutely. With regard to having an ALJ hear the case with the cost, both the licensee and the board would have to hire numerous expert witnesses to explain to the ALJ what the standard of practice is based on whatever the violation is, the ethical standards in place for their take psychology. We have ethical standards we have to abide by. We have professional rules they have to abide by. All of us as laypersons don't know that, and ALJ is not going to know that. It has to be, the board does. Those board members that sit and hear the violations and hear all the evidence, they know what those standards are, but that would have to be taught to an ALJ. And so that's going to involve a great deal of expense to hire all those experts to come in to testify, pay those expenses, and it's going to make longer hearing process for the ALJ, for all people involved. It's not just the board.
So speak to the cost. Who would have to bear the cost of the board? The board?
Yes, the board has to bear the cost, which means the licensees.
And what's your source of revenue?
Our source of revenue solely is licensees. It is self-funded.
So you would have to...
We would have to increase dues for all of our licensees to pay for this.
Thank you.
Thank you.